I'm Gidon, and I'm a lawyer in the Litigation and Dispute Resolution Group here at McCabe Curwood. For those who are not aware, statutory demands are a precursor to the winding up of a company. However, what happens if you serve a statutory demand on a foreign company that is unregistered and does not have a principal place of business or an office in Australia? Can the entity sidestep compliance with the statutory demand because of this? The issue was recently before the federal court in the matter of TCL air conditioner Zhongshan Co Limited, in which the court held that despite being unregistered in the country, TCL was amenable to the Australian jurisdiction and could therefore be validly served with a statutory demand under Section 585 of the Corporations Act. So here's how the court reached this decision. TCL was the manufacturer under General Distributor Agreement with Castel Electronics Proprietary Limited, a company registered in Australia. TCL manufactured and delivered products to a port in China, and Castel arranged for the products to be delivered to and sold in Australia. After several years, the GDA was terminated by Castel after it alleged that TCL had repudiated the contract. Arbitrators published awards with a balance in favour of Castel. Following TCL's failure to comply with the judgment debt, Castel served a statutory demand on TCL solicitors by email. Their solicitors responded, asserting that Castel's demand was invalid, as TCL did not carry on business in Australia. Pursuant to the Corporations Act, an unregistered foreign company may be a Part 5.7 body or a body that may be wound up if it carries on business in Australia. Subsections 21(2) and 3 of the Corporations Act clarifies the meaning of the expression carries on business in Australia. The court observed the general law that whether or not a company is carrying on business in a particular territory is ultimately a question of fact, and that it is not necessary for a company to have an office or maintain an identifiable place of business in Australia to be carrying on business in the country. Instead, the important inquiry is what TCL was actually doing in Australia. Some key factors which helped the court form its view that TCL did have a sufficient presence to be carrying on business in Australia included TCL influencing the sale of products in Australia by entering into separate sale contracts with Castel in Australia that were governed by Australian law, and TCL travelling to Australia on an annual basis to discuss with Castel's representatives on matters such as marketing, retail pricing, and compliance of its products. The federal court's decision serves an important warning to foreign companies who may believe that they can sidestep the court's jurisdiction if served with a statutory demand. It also highlights the importance of understanding the factual inquiry undertaken to consider whether or not the foreign company carries on business in Australia. Here at McCabe Curwood, we specialise in debt recovery and insolvency. If you wish to speak to someone about statutory demands, including jurisdictional issues that may arise in relation to a statutory demand, as demonstrated in the case just discussed, please don't hesitate to contact us.